214B visa denial. How can you avoid it, and can you overcome it? Mark was extremely happy as his sister, Adonica, was coming to the U.S. to visit him in 3 days. Suddenly, the phone rang. Mark could not believe his ears. Adonica told Mark, "I'm not coming. The consul refused my visa under 214B. I don't know what to do." Adonica is not the only one to fall prey to 214B visa denial. On any given day throughout the world, many people will find themselves in Adonica's situation. They hear the consular say, "Your visa application is refused. You are not qualified under Section 214B of the Immigration and Nationality Act." To hear this when you are not expecting it causes great disappointment and sometimes great embarrassment when you have to change all of your plans. For many applicants, the consular officer's pronouncement that they have been denied a visa under Section 214B is the first time they have ever heard of it, and few are sure about the reasons for the denial. What does a 214B visa denial mean? And what can you do to prepare for a visa application or reapplication? What is Section 214B of the Immigration and Nationality Act? In Section 214B, also found in the United States Code 8 U.S.C. 1184B, states, quote, "Every alien shall be presumed to be an immigrant until he establishes to the satisfaction of the consular officer at the time of application for a visa and the immigration officers at the time of application for admission that he is entitled to a non-immigrant status under Section 101A15. This simply means that before you can be approved for a non-immigrant visa, you must prove that you will return to your home country. You must show that you have no intention of abandoning your residence there. The law places the burden on you of proof on you to prove that you have strong ties in your country that will compel you to leave the U.S. at the end of your temporary stay and return home. Thus, to avoid a 214B visa denial, applicants must convince the consular officer of the following: that they intend to return to their home country after a temporary stay in the United States, that their financial situation is such that they can afford the trip without having to seek unauthorized employment in the U.S., and that the travel is for legitimate purposes permitted by the applicant's visa category. From the above discussion, one thing is certain: having strong ties with your home country matters a lot when it comes to getting a non-immigrant visa for the United States. At this point, I know you must be asking, what is meant by strong ties? Why is it important? How do I know if I share a strong bond with my country? What do I do if I don't have strong ties with my country? Let's quickly go to the answer for your first question. What constitutes strong ties with one's home country? Actually, there is no standard definition for strong ties. What constitutes strong ties will differ from country to country, city to city, and individual to individual. Ties are the various aspects of your life that bind you to your country of residence: your family, social relationships, employment, and possessions. Some examples of ties can be family, a job or business, a house, a bank account, and investments. Each person's situation is different. Consular officers are trained and are aware of this diversity. During a visa interview, they consider professional, social, cultural, and other factors each person presents. In cases of younger applicants who may not have had an opportunity to form many ties, consular officers may look at specific intentions, family situations, and long-range plans and prospects within the country of residence. Why do immigration officers place such high importance on those strong ties? Many people ask this question. It's very important that you understand the meaning of strong ties if you are applying for a visa. The bond that a person shares with his or her country helps the officer determine that the applicant possesses a residence abroad and they have no intention of abandoning it. In the officer's point of view, an applicant should have such strong ties with his or her home country that they will compel him or her to leave the U.S. at the end of his or her temporary stay to return home. Let's take a look at a quick case. Anju, a young man from Central Africa, applied for a visitor's visa to travel to the U.S. to visit a younger brother living in Atlanta, Georgia. He was denied under 214B because the consular officer did not think he would be coming back. He had not gone to the interview prepared to address the intending immigrant issues. Anju went home, gathered documents to show his ties to the home country. When he went in for his next interview, he was ready. He had a single sheet that outlined for the consular officer all his reasons for staying and attached to it all the documents to support his claim. He started out by showing that all of his family lives in his hometown in Africa, except his brother who is attending college in the U.S. His family owns several pieces of property in Africa. He owns his own business, which he started when he graduated from college, and which is doing very well. The business has several employees and will be run by his office manager in his absence. He also owns his own house and will be getting married early next year. At the interview, the consular officer took the package of materials and reviewed them quickly, asked Anju a few questions about his trip, and granted the visa. Preparation paid off for Anju, and at the beginning of the month, he will be off to the U.S. to spend a couple weeks with his brother. Is a denial under Section 214B permanent? No, as we saw with Anju. A consular officer will reconsider a case if you can show further evidence convincing him of your ties to your home country. You should contact the embassy or consulate or look at their website to find out about reapplication procedures. Unfortunately, some people simply will not be able to show ties to their home country and then, therefore, will not qualify for non-immigrant visa, regardless of how many times they may reapply. This will only change when their professional, personal, and financial circumstances change. What should you do in case of a 214B visa denial? If you are refused a visa under Section 214B, you may reapply. When you do, you will have to show further evidence of your ties or how your circumstances have changed since the time of the original application. First, carefully review your situation and realistically evaluate your ties. You may want to write down on a paper an outline of what qualifying ties you think you have and may not have been properly evaluated at the time of your interview with the consular officer. Also, you should review any documents that are submitted for the consular to consider and look at what documents could have been presented that weren't. It may help to answer the following questions before reapplying. Number 1, did you explain your situation accurately? Number 2, did the consular officer overlook something? Number 3, is there any additional information you can present to establish your residence and strong ties abroad? Note, you should also be aware that you will be charged a non-refundable application fee each time you apply for a visa, regardless of whether a visa is issued. Concluding up here. In conclusion, when applying for a non-immigrant visa, you have to be prepared. At your visa interview, you have to be ready to present your case to the consular officer in a clear and concise manner. You only have a few minutes to convince the officer that you are indeed a good candidate for a visa. You should have all the points you want to make, ties to your home country, outlined, and you should have all of your supporting documents in order and ready to present. Finally, know your travel plans. You should be able to tell the officer without hesitation or faltering the 5 W's. Why are you planning to travel to the U.S.? When are you planning to travel and how long do you plan to stay? Where are you going to stay and who will you be staying with? Who are you planning to see while in the U.S.? What are you planning to do while in the U.S.? While there is no clear definition of strong ties, you can be successful if you are prepared. So, gather your documents, be confident, and good luck. Contact Visa Pro if you have any questions regarding visas or you need help in filing with the USCIS or consulates. Our experienced attorneys will be happy to assist you.